Welcome to the fourth of 5 installments in the webinar series titled Enhancing the Value of Growing Private Equity Platform Companies via Proactive Compliance Initiatives. Today's program will address and provide guidance on proactive healthcare regulatory compliance. Before we begin the presentation, please note that today's webinar is being recorded and participant phone lines will be placed on mute throughout the program. You're welcome to submit questions directly to the presenters during and after the webinar by typing into the Q&A box displayed on your screen. In 2 to 3 business days, Epstein, Becker, Green will email registrants a link to access a recording of today's program and PowerPoint materials. Joining us today are 3 Epstein, Becker, Green attorneys. John Eriksen is a member of the firm in the healthcare and life sciences practice. He regularly counsels clients on a wide range of issues, including strategic development, transactions, interactions with state and federal agencies, and routine and non-routine contracting matters. Josh Freemire is also a member of the firm in the healthcare and life sciences practice. His experience includes working with private equity companies and other healthcare investors and their portfolio companies on a broad spectrum of health regulatory concerns, including fraud and abuse, privacy law, licensing, reimbursement, multi-jurisdictional practice, and entity structuring, compliance, and disclosures. Kevin Ryan is also a member of the firm in the healthcare and life sciences practice. He advises for-profit and not-for-profit healthcare clients on transactions and regulatory matters, including licensing laws, HIPAA privacy requirements, and state and federal administrative matters. He also counsels businesses on mergers, acquisitions, and joint ventures. At this time, I'd like to turn the presentation over to John.
Thank you, David. Thank you all for attending. Today we're going to take a little bit deeper dive into compliance program aspects around platform companies, including the necessity, the characteristics, and the components of those programs. I'm going to give a high level on those issues, and then Josh and Kevin will take over with a deeper dive. So in terms of why is a compliance program necessary, the simple answer is that the government requires it, but a slightly more nuanced answer is that it's good business practices to have these controls in place around the risk areas of a company, and as we dive into the interactions of the compliance program with the rest of the company, that should become more clear as to why those controls make for a more effective organization. The characteristics of a compliance company, or program rather, are that they are not just policies in a drawer. It has to be an active program that is proactively seeking out potential risk areas and attempting to resolve them and attempting to train people in order to avoid them, and in that process is serving the organization not really as a police officer of the organization or as an internal affairs officer, but is working with all aspects of the organization to avoid issues and to resolve issues that arise. So in terms of components of a coordinated program, any program would have some thinking around identifying risk areas pertinent to the organization, preventing those risks, and training personnel to identify and report such risks and to avoid them as possible. To the extent that risks are identified, to remediate and correct any damages that have caused, and certainly to avoid further expansion of the risk that has been identified, and then to the extent necessary to discipline and further train employees on the risk that has occurred. And then there should be a feedback loop going sort of all the way back to the beginning, which puts any identified risks back into the risk category that you will continue to be looking for. Why does this help the organization? So the organization is in the process of both controlling for risks overall, but also any compliance program that is serving the organization in terms of training and identifying issues from the viewpoint of accuracy is not only mitigating risk, but likely also identifying opportunities for revenue enhancement and also avoidance of issues that can be quite costly. Additional positive effects, you can change please, David. Additional positive effects around any functioning compliance program is that you've got better trained employees. Employees are independent actors because they have the knowledge to behave in a compliant manner and do not require constant micromanaging by supervisors. Overall, the documentation and the record keeping of the organization becomes better, and this goes to both compliant behavior as well as revenue enhancement to the extent appropriate. You mitigate things from a revenue cycle perspective in that the increased and better documentation leads to fewer provider payer disputes and denied claims. And then just from a employee / customer patient reputation in the market perspective, you'll be viewed as a positive player, and that overflow goes not only to employees who are less likely to complain and turn you into the government, but also to the customers and eventually regulators. Regulators do take stock of players that they believe are good players in the market. And so with that, I'm going to turn it over to Josh to run us through some of the 7 elements.
Sure, and anyone who's familiar with the compliance universe has seen the 7 elements. They're set out by the OIG in a variety of their compliance guidance, and they are what is necessary when we talk about an effective compliance program. What the OIG means by that, what lawyers mean by that, is compliance programs that meet the 7 elements and actually effectively inhibit improper conduct. So the 7 elements by themselves can be a little confusing. It's helpful when thinking about these in terms of a recent acquisition or a recent add-on to think about how do we go about these. And these have been put in a circle because they aren't really described in any order, but I'm going to give you the order. So first and foremost, you want to consider who is going to be in charge of your program. Experienced professionals in the compliance universe make a big difference, as most compliance officers will tell you. They have worked in these fields before. They understand how employees think and how to sort of structure programs so that they are most effective. You also want folks who are familiar with your specific industry. You want to avoid what I see a lot, especially in smaller companies, which is people who are asked to wear multiple hats. That can get overwhelming. So, and the OIG and CMS have both sort of spoken out about the problems of having a compliance officer that's also the GC. Once you have the who, you can work on the what. Written policies and procedures should be customized for your organization. They should respond to the real risks that your organization actually faces. So real billing issues or real risks of fraud and abuse that your industry faces. They should be updated at least annually. You should take a look at them regularly to see how changes in the industry or your company has changed them. You want to make effective training and education decisions. So test frequently, and you want to document your education so that no one within or without the organization can say you didn't tell people how to do this appropriately. You're going to set up effective lines of communication. Everyone's familiar with a hotline, the compliance hotline, but you should set up email and even text. Certainly younger generations prefer to use text and they prefer anonymous communications. Better to have too many options than too few. And part of this communication requirement also has to do with the compliance group, the compliance professionals, up to management and the board. You really want to have a direct line between your compliance group and the board, preferably a compliance committee on the board. Internal monitoring and auditing, we've talked about that a little bit in prior presentations, so I won't belabor it here, but you want to identify and review specific risk areas for your industry, your company, and really dive into those. To the extent you identify something that you believe is an issue, you're going to want to involve counsel early, maintain privilege when an audit or a review becomes an internal investigation. In terms of disciplinary guidelines, be careful drafting them because you will need to follow them, including for valuable employees, so you don't want to make them too harsh. Responding promptly to detected issues is going to require kind of pre-programming a little bit so that where you have an issue, you know who to contact, whether that be outside counsel, outside billing consultants, internal folks who are going to lead the investigation. You want to have that a little bit thought out beforehand. So we can flip to the next slide because the next question is, what are the must-have elements in terms of these programs? And the answers are going to vary industry to industry. Every industry has its own risks, and it's important for an effective program to think about those risks in your specific industry and customize the program appropriately. But there are some common themes. In terms of where to find some information on common risks in your industry, there are some places you can look right off the bat. There's compliance guidance issued by the OIG for multiple industries out there, including long-term care and home health and a few others. If you're in those industries, that's a great document. You want to model your program closely off of that. The OIG also publishes annually a work plan that walks through its enforcement priorities for the year. There almost certainly is an item or items dedicated to your industry. You should know what those are every year and make sure that you're focused on that area. Federal fraud and abuse is a recurrent issue that's going to be across everybody's timeline. Are you billing federal or state healthcare programs is the first question. Do those laws apply to you or your line of business? Do all of them apply? For instance, Stark and others have limitations built in, so they may not apply to your line of business. You want to consult with your professionals and your attorneys to determine that. In your policies and procedures, when you're describing those federal fraud and abuse issues, you don't want to just list the laws. You want to provide real-world examples. Specifically, how do these impact how we get patients? How do these impact how do we get paid? Those are the issues where you're almost always going to see fraud and abuse concerns. You should include an enterprise-wide code of conduct that should be widely known and understood. It frequently gets bogged down with a fair number of buzzwords. It should be pretty clear, and it should be pretty clear when it's read and very clear to understand even for folks who are not compliance professionals, not attorneys, not C-suite executives. Some kind of internal monitoring or auditing is going to be key. How much you do of that and what form it takes is going to depend on the industry you're in. Your internal reporting, communications, and investigations, those are going to be ongoing concerns. You're going to want to have that in almost no matter what industry that you're in. Employees should not have any issues reporting up. Reports have to be followed up on. If there's a complaint and there's a creditable claim of misconduct, you're going to need to follow up on that, investigate it, close it out, and document that you've done so. And again, training needs to be enterprise-wide and well-documented. So some issues, if we can flip to the next slide, some issues kind of require specific separate attention. Privacy and security is one that is going to be across everybody's radar. Should be a part of your compliance program. Your privacy and security structure should report into your compliance structure and in that way make their way to the board. But they really warrant their own separate structure. Typically speaking, compliance professionals are not necessarily an overlapping skill set with privacy and security professionals. That doesn't necessarily mean that you need to have full-time privacy and security officers, although depending on the size of the company you might. But there may be folks within the existing infrastructure of the company, usually in the IT department, that can work in that capacity. And they can report up to the compliance officer so long as there are structures in place that everyone understands what the issues are and how they're being addressed. It's important to think about both federal HIPAA laws. Obviously, everyone is familiar with those, or at least knows they're out there. But individual state laws have come on recently, and they've come on fairly strong. They can have broader definitions of protected or covered information. They can include private rights of action so that individuals can sue where their security or privacy has been violated. They can have broader definitions of breach events so that something that would not be a breach under federal law may be one under state. They can include shorter timeframes for notification, so less time to respond in certain states. And they can include additional notification requirements. Frequently, they require you to notify, for instance, the state attorney general or another state authority. So whatever your privacy and security program is, it needs to be customized to pay attention not just to the federal level, but also individual state laws where you operate. Privacy and security policies almost certainly will need to be separate from your standard compliance program. They're going to need to be specific to the needs of your organization, and they really, the path to drafting those begins with a risk assessment, which is a term that folks have heard, but maybe is not as widely understood as it should be. That should be a no less than annual review of all of an organization's security and privacy procedures and structures. You identify your weak points, you create a work plan for the year moving forward, and you work on addressing those. So that's an ongoing process, and it's something that should be done at least annually. To the extent you're working with a new company or recent acquisition, and you either believe or suspect there may be privacy or security issues, it's worth considering involving counsel in an initial security audit and an initial risk assessment so that the results of that and the determination as to how to move forward with it remain privileged. Flip to the next slide. Much like HIPAA, there are also state fraud and abuse statutes, which often get short shrift when discussions of risk are talked about. I will move through these quickly, but you should always consider the states in which you're operating and the specific laws that apply there. So a compliance program is going to, by necessity for a large organization, include state-specific reviews or state-specific checks. In individual states, you can see state self-referral prohibitions. They may not be limited to physicians only, like Stark is, and they may be different depending on the specific provider that we're talking about. So, for instance, in Florida, there are specific self-referral rules that govern imaging that don't apply to other ancillary services. There can be state anti-kickback statutes. Unlike the federal anti-kickback statute, these can apply to all payers, so not just for federal or state healthcare programs, but private insurance as well. They can skip the safe harbors that are provided under the federal statute, and the penalties there can be civil rather than criminal, which importantly means that an analysis is not going to offer you the safety of, well, you lack a criminal intent, so we don't think the risk is as high. Doesn't mean there's strict liability, but it means that they'll require special attention, and you should certainly be aware in a multi-state organization whether or not you have an all-payer kickback statute in play. Fee splitting, very similar. It's going to vary widely state to state, how it's triggered. It's frequently linked to referrals, but not necessarily so. And some states have defined that quite broadly. Again, Florida as an example, where marketing or advertising services can trigger the application of the fee splitting prohibition. This is a significant issue for management service entities where they're operating in a friendly PC structure with professional entities. So always something, again, that you're going to want to be aware of and pay special attention to. Flip to the next slide. I am running low on time, so corporate practice, again, this is a specific issue, and for compliance programs for management service entities, corporate practice prohibitions are going to play a strong role in terms of how those are structured. Most importantly, there needs to be a compliance program both for the management company and for the individual practices. You want to maintain a separation between those two entities, which means they're each going to need their own compliance program, although the management company can certainly assist individual practices in putting those together. Practice compliance programs should include clinical provisions. Management companies obviously should not. They shouldn't share personnel, but on an individual professional entity basis, there can be a little bit less formality to that structure. It could be a single person or persons who's going to assist the management company in overseeing the compliance program. The practice should have its own training. It should all be branded with the practice's own name. And again, the separation of the entities should be clear throughout the materials that are provided, both in terms of policies and procedures and training that are provided to individuals at both the management company and the practice to make sure that they understand and maintain the appropriate separation between those two entities. And speaking of how to structure these and maintain appropriate separations, I will turn it over to my colleague, Kevin Ryan.
Thanks, Josh. We're going to look at some key organizational features right now for compliance, and then next slide we'll talk about corporate practice a little bit. But you've heard about why it's important to have a clearly defined compliance program and what the seven elements are of a compliance program. This is a little more operational in nature. The leadership, it's as Josh said, you should have a head of compliance who has the appropriate training and background, have it separate from legal and from accounting probably as well, so that it's clear that the decisions are not being based on financial decisions, but the compliance issues are independent. The compliance officer should have a reporting relationship that goes to the board. It's good if there is at least a board committee or some representative of the board who deals with the compliance officer, and that the compliance officer can always go to that person, even if they have another reporting relationship, say, to the president of the organization. That compliance committee should also meet on a regular basis, say quarterly, or maybe it's monthly. And there should be minutes of those meetings. A lot of people don't like to go into great detail, but they can say that the compliance officer met and presented the current compliance issues, or addressed some of the things, so that it's very clear that they did meet, the board took action, or that at least the committee took action, and the board then made decisions based upon that. The written policies, Josh mentioned that there should be a very clear code of conduct, and it's important that the compliance program itself start at the top, and that the leadership not only approves it, but they implement it and they live by it. You can't expect all of the employees to follow a compliance program if it's not something that the leadership has not bought into and really takes to heart. So having that code of conduct is very important, and as they mentioned, that there should be compliance training, there should be policies and procedures. The training should be yearly for everyone. A general compliance overview. The policy itself should be, if there's a separate issue or a separate, sometimes there's publications from the compliance department where they put out general updates to everyone, or there may be a site, an intranet site that companies have established where you can get all of the compliance policies and procedures, as well as the HIPAA policies and procedures. And it may be important as well to update and to train more often than yearly if there are certain things such as some billing and coding issues that may have changed, and therefore people are going to have to be updated on that and know what the current developments are or the current requirements are. In terms of focusing on specific risk areas identified in guidance, the OIG's website has a wealth of information, including all kinds of compliance guidance. I think that over the years, the OIG has put out guidance for just about every type of provider. You've got nursing facilities guidance. There's guidance for hospitals, pharmaceutical manufacturers, home health agencies and hospices, physician practices, ambulance providers, labs, billing companies, and in this guidance, the OIG sets out what they think that these type of entities should look for, what type of programs they should have. in terms of putting together a compliance program, and so it's very helpful. Sentencing guidelines are also a source of information. Corporate integrity agreements that the government enters into with providers who have settled various allegations of fraud and abuse or some other type of violation of the healthcare laws. It can give you an idea of, again, the type of information or the type of activities that the government is interested in and sees as fraud. And the CIAs are available as well. They're publicly available on the OIG's website. And the OIG's website also has fraud alerts that, again, over the years have provided a lot of information on different types of practices that the OIG is concerned about. And these include things like lab payments by referring physicians or to referring physicians, joint venture structures, drug marketing practices, marketing services or telemarketing services for DME suppliers, physician-owned entities, and waiver of copays. So again, if you're going to go into any of those types of activities or your program involves any of those, it's very important that you see what the government was concerned about when they issued that guidance. And in many cases, that guidance, even though it may have been issued 20 years ago, is still things that the government is looking at and using in analyzing different types of deals. And finally, on the communication structures, hotlines and reporting, as Josh mentioned, it's important to have different types of reporting mechanisms. It could be, text, ability to text. It could be there's email, communications, a website that the compliance office maintains, or a hotline, a 1-800 number, and not only important for your employees to know that, but for your if you're providing services for the patients as well, for your vendors to know that they can call that if they believe that there is some type of issue. And again, it's important if that communication comes in that it's actually followed up on, and there should be a policy and procedure on how you're going to actually implement those reporting, following up on all of those issues. So we can go to the next slide. And this has to do with corporate practice, as Josh was just talking about. In corporate practice of medicine issues, the corporate practice is a state-specific and profession-specific prohibition. In some states, certain professions can't be employed by general business corporations. It ranges from a state like New York, which prohibits nearly any licensed professional from being employed by a general business corporation, to other states that have no prohibition whatsoever. There's many states that fall in between. You've got states like Louisiana and Delaware that only prohibit optometry being employed by optometrists being employed by a general business corporation, to other states where, like Michigan, that have a learned profession criteria where they have very limited professions, like lawyers and doctors, and divinity from being employed by a business profession. So it's important that you know if there is a prohibition in the state. And if there is, then professional decision-making, the clinical decision-making really needs to be made by the professional corporation, and management company needs to stay within the realm of business decision. Now, that doesn't mean that you can't have coordination between the two. There may be many things that the manager can help a practice with, but the final decisions are made by the practice themselves, and those could be things like the hiring and firing of the professionals employed by the professional corporation, final pricing, payer contracting, the hours worked, the ultimate services that are offered, the treatments prescribed, and those are all things that the management company can help on. So in terms of hiring and firing professionals, management company can always help a professional corporation maybe do some of the recruiting. They may be able to do some of the assistance in terms of disciplinary actions, but the final decisions need to be made and signed off on by the practice themselves. So what does that mean? That means that the owner of the professional corporation should somehow designate their approval, whether that's through an email or a document where they sign off on the ultimate hire or termination, or the hours worked. Same thing with budgets. Budgets can be things that the management company can put together and present to the professional corporation, and then the professional corporation signs off on it. Now, there may be things that the management company has sole control over, maybe things like the electronic health records in terms of some group purchasing contracts and other supply contracts. As long as they don't impact the profession, they should be fine. But collaboration is usually the key here, and it requires interaction and a cooperation between the management company and the professional company. Next slide. So implementing, there is no effective passive program. In terms of compliance, you, as has been mentioned a couple times, you definitely need to have a training program. And depending upon the positions that are being trained, you need to have that training at least at higher and yearly. And as I mentioned, there may be some other positions that you want to train even more frequently as things come on, or if processes change throughout the year. Training should be mandatory, and the board should receive training as well. I mentioned the OIG website earlier. The OIG website actually has some really good materials. They've got toolkits. They've got resources for the board, and they even have some sample training that can be used. And training may also vary depending upon the position. So billing and coding people may get trained on far more than, say, somebody who's just working reception. They may need to know about more about some of the fraud and abuse issues. They may need to know about billing and coding practices, what they can do or not do when billing and coding their profession. The same thing in training the professionals who are going to be billing and coding for services. They may need to have far more training on what is allowed and how they can bill and not bill. And there should be policies and procedures regarding all of those types of things. Background checks are another thing that is required. Those background checks should be done at hire. They should also be done, exclusion checks should be done monthly. There's the OIG exclusion check, which is the list of excluded individuals and entities. There's also the SAM, which is another exclusion check, and you want to check both of those. You want to make sure that the individuals have not been excluded from participation in Medicare or Medicaid, because that also not just your employees but board members. Because if they have been excluded, any type of reimbursement claim submitted when those people have been in those types of positions will be rejected and will not be allowed to be filed, have to be repaid. You want to review and update the policies on a regular basis. One thing that's important is maybe to have a policy date on it so that it's clear when the policy was adopted, and then when it's up for renewal. That way anybody looking at it knows that the progression of the policy. They also know if it's current. And if you say that you're going to review it at a certain time, then it should be reviewed at that time. It was already mentioned that there should be annual risk assessments done, and these can be both internal and or external. And then there should be the updates. If you find things that need to be changed as a result of the assessments or as a result of the policies, then you need to implement it. Just documenting that you looked at the policy but not actually implementing any of the changes is not going to be helpful. And then if you do update it, again, that's a reason that you may require additional training throughout the year so that everybody knows what the update is. And all training and assessments should be documented. It could be that if it's done online, that there's a way to get electronic verification, and all employees should be tracked as well as board members, or if they are in-person meetings, there should be a mandatory sign-in sheet. And if it is determined after you've looked at all of this that they haven't signed, an employee hasn't, then managers should follow up to make sure that all training is done. And if you can't document that you actually did it or that employees did it, then no one's going to believe that they actually did. Next slide. So you want to follow your own rules. You want to perform your audits as scheduled. These could be internal or external. Lots of people have schedules where they're going to do certain billing and coding things on a regular basis. They may do external audits on a less frequent basis, maybe quarterly or annually. You want to record the results and follow up. And if you can't meet the schedule you originally set, then change the schedule because, again, if you've got a policy and you don't follow it, that can be sometimes worse than not even having the policy. So you want to definitely make sure that you're following what you said you were going to do. You actually have to follow up if you have issues that are disclosed, and you want to follow them up to closure. Sometimes these things are going to take a long time, and so in order to show that you're working on them, you may want to put together a plan so that you can document the steps, not just say that we're working on it, but you can show what the posts are, the different things that you're going to get done, and prove that you actually are moving along that path. You want to try to have information privileged where it can be. If wrongdoing may exist, involve counsel and investigate. Sometimes even when you're engaging the consultants, you want to do that through counsel. And so, again, you want to be talking with the compliance people. You want to talk to counsel, legal counsel, internal and external, to determine when activities should be engaged through counsel. Reporting and correcting errors. Again, this is both internal and external. If you find out that something was paid that shouldn't have been paid or there was an overpayment, you need to repay it in accordance with either the Medicare guidelines, if it's Medicare payment, or contractual provisions if it's a third-party payer. And then make sure that if you do find out that something's gone wrong or somebody violated the policy, there should be discipline, and the sanctions could range from oral warnings to termination. Again, it's probably governed by the policy itself, but you have to follow your rules, and you can't have the punishment vary just because a certain employee may be more valuable to the entity. You have to be consistent. So next slide. And you need to stay up to date. So compliance officers and counsel need to understand industry trends. There's enforcement trends. There's a lot of resources out there. There are compliance programs, organizations that put this out. Obviously, law firms provide some of this information on a regular basis, as well as what some of the common risks are in the industry. And you can also, there are many resources to see what the government and the payer are focusing on in terms of different types of areas. The government also puts out advisory opinions to give some information. about some of the things that they see, questions that they're getting asked as well. You could designate a person or a group to remain on top of certain industry issues. So you could have somebody monitoring billing and coding for your profession, or monitoring HIPAA privacy and security issues, monitoring enforcement actions related to data breaches, those types of things. There can be, and then reporting back to the compliance officers or committee. Chances to comment on legislations or regulations on a fairly regular basis. We will send out blogs that say that there's certain requests for comments on federal regulation. This also happens at the state level. So again, there's opportunity for you to provide input and to make sure that if legislation or regulations are passed, that you've at least had input into it. Do the same thing with state laws. Medicare has the Medicare administrative contractors, the MACs, often issue local coverage determinations. It's important that you follow these as well. These things can change, and of course it can be the difference between getting reimbursed for a service or not. Pending changes to covered populations, like Medicaid expansion. Again, this is a statewide issue, but lots of states have proposed or implementing Medicaid expansion. It's important, if you're in that business, to know how that's what the changes are going to be and how it's going to impact you. But I guess the most important thing in all of this is that you should be prepared for change. If there's one thing that anybody who's in healthcare knows, is that none of this stays the same over time. There's constant change, and you and your teams will need to stay up on it. So I think that's it for purposes of my presentation. So I think we have some time for, I'll turn it back over to David for some questions if there are any.
Thanks, Kevin. It doesn't look like there are any questions. I encourage you, if you have any, to feel free to reach out to our speakers at the contact information that's listed on your screen. I thank all of our speakers and our attendees for their time. A reminder that in 2 to 3 business days, Epstein Becker Green will email registrants a link to access a recording of the presentation and PowerPoint materials. We hope you'll join us for the final installment of this series, which is scheduled for next Tuesday, October 30th at 12 p.m. Eastern Standard Time. Presenters will discuss various employee benefits and executive compensation issues that must be addressed by platform companies in their compliance efforts as they structure the transaction and move forward with operations. For more information and to register, please visit www.ebglaw.com/events. Thank you all for attending.